Hi, my name is Max Frizalone, and I'm a criminal defense attorney here in Maryland. In this video, I'm going to be answering the question of what happens after a person is arrested in Maryland. Let's start with arrest. So an officer places a person in handcuffs. They're physically under arrest. What options does the officer have? Well, the officer might choose to let the person leave with a criminal summons, a criminal citation, or some traffic citations, or in the alternative, the officer may take the person to a detention center and begin the booking process. So, first we'll deal with the easy one. An officer decides to give the person a criminal citation or traffic citations. We see this often in DUI cases. Person is arrested on the scene, taken to the station, paperwork is processed, they're asked for a breath sample, and then they're released to a sober driver. We also see it in theft cases. Target, you forgot to scan some items, an officer is called, you're given a criminal citation for theft and asked to come to court. You're not taken to jail. Now, the officer doesn't have to do that. They can go with the second option in any criminal case, and that is to take you to a detention center. So depending on where you're arrested, you may be taken to one of your county's detention centers. Some counties have more than one. You will then be brought through the booking process. Your property will be taken away and put somewhere safe. Your photo will be taken, your thumbprint may be taken, some biographical data from you may be asked about. Ultimately, all of your information will be taken by the facility so that you can be booked in and processed in. Once that's complete, you'll then see a commissioner. A commissioner isn't a judge, but they do much of the same as a judge would do at an initial appearance. They work 24/7, and their job is generally to advise you of your charges, advise you of your right to counsel, and make an initial bail determination. So, they'll ask you some questions about your employment, your bills, and those are to qualify you for a public defender or disqualify you. Then the hearing will begin. You'll be informed of your charges, and your attorney and potentially a state's attorney can make arguments about whether or not you should be released. That commissioner will decide whether or not to set a bond. Typically, commissioners are setting money bonds, either secured, meaning you have to post money, or unsecured, meaning you agree to pay money if you don't show up. Once that's completed, you may bond out if you're given a money bond. But if you're not given a money bond and you're held without bond, you will then be scheduled to see a judge at the next available court date. So if you're arrested on a Saturday night, you'll probably see a judge Monday morning or Monday afternoon, depending on when the district court for the county that you're arrested in is working. After you see a judge, you can again be given some sort of money bond, or perhaps there may be more options for release like private home detention, pretrial services through the county that you're arrested in, etc. If you're released, then you'll receive your trial date at the hearing you're released at, or sometimes with the commissioner. If you're held without bond, you'll receive your trial date while you're incarcerated. You may hire an attorney in the time period between your initial bail review and your trial date to try to secure release, and that will have to come through a motion, and a judge will decide whether or not they want to hear your bond again. Now, depending on the type of charges, you may immediately be scheduled for a trial, or you may be set in for what's called a preliminary hearing. If you're charged with felonies, certain felonies, let's say a violent felony like robbery, but your case is in the district court, then that court doesn't have jurisdiction or the ability to have a trial on a robbery. So instead, they'll set this hearing called a preliminary hearing, and that's essentially a hearing for the state to either dismiss the felony, put on a witness to testify to the probable cause for the felony, or have indicted you by then and remove the case up to the circuit court. If you're charged with a district court eligible felony like felony theft, you'll immediately get that trial date. So it depends on the type of felony you're charged with, whether or not you're going to get that preliminary hearing or go directly to trial. In the time period between your bail review and your trial, you should talk with some attorneys or secure a public defender. If you're released, it's quite easy to contact any attorney like us or any other criminal defense attorney and set a consultation. If you're incarcerated, you may need to rely on some family members to do that. If you were given one of those criminal traffic citations or a criminal citation for something like theft, you may not get a trial date immediately. You may get what's called a preliminary inquiry. That's a hearing where you're informed of your charges and instructed to get an attorney. That might occur also if an officer had chosen to charge you by summons, going and writing out an application for a summons. Every case is different. Ultimately, your case will eventually go to trial, whether it's in the district court or circuit court, and that's where the state has to prove beyond a reasonable doubt each of the criminal offenses that you're charged with. Now, if you want to know about what's going to happen at your trial, you should hire an attorney. And so I'll end with saying this. If you have a criminal case in Maryland and you're looking for an attorney, we'd be happy to help. You can give us a call, visit our website, submit a consultation request, or schedule your own call through our website. We'd be happy to help. Good luck.